Տարիների ընթացքում ձեռք եք բերում սեփականություն, կուտակում եք մեծ գումարներ, իսկ մտածել եք, թե ինչ է լինելու դրանց հետ ապագայում։ Լավագույն որակավորում ունեցող իրավաբան Մարիա Պրիմուշկոն իր բազմամյա հաջողակ փորձով կօգնի ձեզ ժառանգության փոխանցման, կտակ կազմելու եւ ձեր ունեցվածքն ապահով պահելու հարցում։ Estate planning, bankruptcy, personal injury եւ այլ իրավական հարցերով դիմեք MVP Law Group։ Ձեր ընտանիքի ապագան կախված է այսօրվա կայացրած որոշումից։ 818 788 7881
Good evening, dear friends, and welcome to our MVP Law Group show. As you know, I'm Maria Primushko, its host and attorney. And during our programs, we talk about important legal issues that affect our communities. Well, today is a holiday. It is a holiday season now, and everybody exchanging gifts. And hopefully you and your family are healthy and happy and welcoming this holiday season. So, what an attorney can give as a present? Of course, it is expertise and knowledge. So today I wanted to summarize all the issues and concerns and situations that we've been discussing in our prior programs, okay? So I'll try to keep you informed and entertained at the same time. So we can start. So before we start, I wanted you to understand that even if some of these things seems boring to you, or you don't like the way I speak, I care, but if one of you will start thinking about all these issues and specifically is going to take action and start doing something about it and protecting your family, my mission will be accomplished. I am happy. I'm happy to share my knowledge and expertise and hopefully push you into the right direction, and you will start your year right and check mark one of the resolutions that people make every year. Because I hear from my clients that, we've been thinking about estate planning, we've been thinking about creating a will or trust all these years, and always in New Year's wanted to start doing it, but something, of course, life takes its turn and people forget about it. All right? So I will call it story of the day, but we will summarize it into one evening of our show. First, I wanted to go back and discuss 3 important forms that each and every person must have: health care power of attorney, HIPAA authorization, and power of attorney. Let me tell you the story. Today, literally today, I received a call from a lady who wanted me to go to the hospital and prepare power of attorney for her dying cousin who is dying at the hospital from COVID. Well, none of us want to pass away. We all think that we're immortal. We all think that there is time. We all think that we will take care of it someday, sometime. But let me tell you, this lady didn't plan on going. As a matter of fact, they tested her numerous times for COVID, and tests came negative, but she's at the hospital, and it's impossible to get access to her. So it is too late in this situation. My firm, we do make emergency calls. We do go to the hospitals. We do go to the nursing facilities for those people who procrastinated enough and now in dire situations, and their families want to make sure that they have power of attorney to talk to the bank, to talk to the attorneys, to talk to Medicare services, all kinds of organizations on behalf of person who is disabled now and cannot act on his or her own behalf. So this lady called, and what can I tell? It is almost too late. So we are looking at different accommodations, see if hospital will accommodate us somehow to prepare certain rooms so me and notary can witness and talk to this patient and possibly client to prepare all those final documents. She asked for power of attorney, but actually, when I looked a little deeper into her situation, this lady needs a trust because there is real estate, there is some significant assets. But since nothing has been done, and if life takes a turn and she passes away, what's going to happen? I will have to represent this family in probate court. Because if there is no will, or if there is no living trust, then there is a probate. Because only person who owns the asset, if you remember, or a probate judge has a right to transfer title from prior owner to a new owner. And heirs, those who inherit the property, are considered new owners, and only judge will be able to transfer the title. So it is so important to have these documents. Please, please check yourself, your family, check your friends and distant families. Make sure they all have power of attorney for financial and legal matters, healthcare directive to have a right to make healthcare decisions on behalf of a disabled person who cannot make those decisions themselves, and HIPAA form, a right to access to protected health information. Otherwise, it's out of your hands. Doctors have a right not to talk to you. As a matter of fact, I had clients who were divorced for certain reasons, but still were living as not as a family, but very close friends and family members. They lived all of their life together, but had to divorce for some reasons. I've prepared these 3 forms for both parties. And several days later, ex-husband had a heart attack. And if they didn't have these documents, ex-wife wouldn't have a chance to take part in her ex-husband's life, healthcare, arrangement for transportation, arrangement for taking care of medical bills, financial matters, etc. Also, we talked in our prior programs about young adults. Those adults, 18-year-old adults, leaving our nests and going to the university across the state. And, we don't know what can happen. It could be an accident, it could be an illness, and you as a parent, you want to have a right to take part in your child's health. And so it is very important. Please consider it. Also, we talked about when people are not married. There is nowadays a lot of families live as partners. They live as husband and wife, but don't get married for a while. Still consider themselves fiancé and fiancée. Let me tell you, if you're not legally married, you cannot take part of your loved one health, financial, or legal matters. So it is also very important. So we've discussed how this lady couldn't receive a body of her beloved man who she lived with for 8 years, and he suddenly passed away. And because she's not a relative, because she, on paper, nobody to this guy, she couldn't get the body from the hospital and provide for proper and fast burial. So she had to go through probate proceedings, ask the judge to sign a paper that she has the right to receive the body. Very sad story, but true story, and totally avoidable. The saddest part about it, that it's totally avoidable, had he prepared these 3 forms, okay? So let's move to the next matter that we've discussed. The story. There was a guy who was married once, divorced, then married again, and had a wonderful family. Lived with this new family for 15 years. They had beautiful children, minor children. and he had his life insurance policy. Well, when he passed away, we looked at all the, with his wife, we looked at all the assets that were available, and we found this life insurance policy. But let me tell you, the unfortunate part that he didn't take a chance, didn't have time, or whatever, it's always later, right? It's always tomorrow that we'll take care of important stuff and some paperwork that we have to be prepared for. So it happened that he still, on that life insurance, had his ex-wife of 15 years ago as a beneficiary of this life insurance. So this ex-wife became a happy woman. I think the policy was for $500,000. So she received that $500,000 15 years later as a gift from her ex-husband. Good for her, but not good at all for these young children and for this family who was certain that they have some assets after his passing, but they did not. Again, sad story, but totally avoidable. Only thing that you have to do, so if you own a life insurance, if you have 401k, IRA accounts, a pension or retirement plans, please take a look at them. Call HR, call the policy. If you don't have these documents on you, if you don't have it in your house, you have to have it. Call and request original agreements that you signed with them, and ask if your beneficiaries have been designated. All right, so name the right beneficiaries. They have to be current. So whoever you decide that will take after you has to be on that paper. If you have a living trust and have minor children, I strongly recommend naming living trust as a secondary beneficiary. So if you usually spouses name each other as the first beneficiary, and then it is customary for people to name their kids in equal shares as secondary beneficiaries. However, until your children reach the age of majority, I strongly recommend naming a living trust as a secondary beneficiary in case of catastrophic event, you and your spouse passed, and we want to make sure that the proceeds from life insurance or any other account are readily available for your minor kids, that we can fund the trust. We don't have to wait, your kids do not have to wait until they reach the age of 18 years old and then suddenly receive $1 million. They're not ready for it, right? So I recommend that those monies start working for your kids right away for their education, support, paying off mortgage, or any other substantive purposes instead of a young adult going crazy, having suddenly this amount of money. All right, because there was also a story, my recent probate case, when wife was certain that there is life insurance policy, but husband also the husband who passed away also created this policy when he was still single, and he still has his mother as a beneficiary of that policy, and mother received all the funds. So I guess it's better than ex-wife, but still we're not sure if it was his intent, if he really wanted his mother to get the full benefits of that life insurance policy. So that is my second recommendation. Then we've discussed in our prior programs, if you own real estate, how do you own title to that real estate? It could be a house, condominium, townhouse, your vacation property, your income property, whatever you name it, it is still your real estate, your real property. And when you purchased it or refinanced or did any other transactions with it, you either got it in your own name as a sole owner, or if you are husband and wife as joint tenancy with right of survivorship, or husband and wife as your community property. Remember, we discussed that the worst thing you can do is owning property as joint tenants. But anyways, if you have real property, you should and must have living trust, just in case, to make sure that your loved ones are protected, that if you're older, that if your parents are older, that Medi-Cal will not come back and ask for reimbursement for the services provided to the older person or young person if there is serious illness for that purpose. So be careful. I would highly recommend for you to go back to your paperwork and review in what way you hold title to the property. If you do not have the paperwork, because I know, because it is very often that my clients cannot locate any documents, especially originals. And nobody has originals nowadays as to deeds. You know, when they purchase the property, show me the deed, and I'll tell you, 80% of people cannot produce anything. So I do my own title search. What you can do is talk to your realtor, real estate agent that you know, do title search yourself somehow at the county, or you can call my office. I can do it for you as well, just for you to have knowledge. So be careful, because, for example, in prior situation, we discussed that sometimes couples get divorced for various reasons. And also sometimes we know that couples, husband and wife, purchase property in one name, either in husband's name or in wife's name for whatever reasons. So you acquire title, let's say, as a wife, as a married woman, as her sole and separate property. And at the same time, husband signs off on the deed saying, quitclaim deed saying that he has nothing to do with this property. He agrees that his wife owns it free and clear. So what is the concern? The concern is, and this is the case I have right now in court, that again, title on the property can be signed off to another owner only by probate judge if property owner died. Okay, so this lady died and she had her a house in her own name as a sole owner, married woman at her sole and separate. So now it's been 6 months that we're in court, several proceedings, all procedures have to be done. Hopefully beginning of January we'll have the petition approved, and the judge will sign the order saying, okay, the property now belongs to husband because it was their community property. The problem with this is that if there are older children, especially, they have a right to the inheritance. And older children, adult children, they have to actually sign off that they agree that this property goes to their father, right? So, but they may not want to do that. You know, every family is different, every relationship is different, and thank God in this family, they all love each other and they think it is fair and reasonable to do. But in some families, it could be a different story, and adult child may decide, hey, no, I want part of it. Let's sell the property and split proceeds accordingly. And in that case, husband, surviving spouse, and their father wouldn't have a place to live, which wasn't, I'm sure, the intent originally. All right, so be very careful with this. Who owns the property? Check your title. All right. And with that, we finish this subject. Please welcome our commercial. We'll be back.
Տարիների ընթացքում ձեռք եք բերում սեփականություն, կուտակում եք մեծ գումարներ, իսկ մտածել եք, թե ինչ է լինելու դրանց հետ ապագայում։ Լավագույն որակավորում ունեցող իրավաբան Մարիա Պրիմուշկոն իր բազմամյա հաջողակ փորձով կօգնի ձեզ ժառանգության փոխանցման, կտակ կազմելու եւ ձեր ունեցվածքն ապահով պահելու հարցում։ Estate planning, bankruptcy, personal injury եւ այլ իրավական հարցերով դիմեք MVP Law Group։ Ձեր ընտանիքի ապագան կախված է այսօրվա կայացրած որոշումից։ 818 788 7881
Welcome back to MVP Law Group show, and we're touching base on another subject that we've discussed before. It's called funding. That is in case you already created a living trust. All right, so when we create a living trust, we discuss that we create this treasure chest, like a box, where you put all the terms and you decide how, when, on what condition the property will be distributed, will be managed while you're living, while you're incapacitated, or when you pass away. All right. But in order to manage something, it's not enough just to create the trust. Okay, you have to proceed with the process that is called funding. That is transferring assets, all the property that you own, into the name of the living trust. Basically, we have to fill in that treasure chest with the property that you've owned, that you've accumulated so far during your lifetime. All right, because it is extremely important, because you wouldn't believe how many cases there are in probate court when people were certain that they have living trust, that everything is good, but when they come to me, I review the documents, and just to find out, I do the search, the title, assets research, just to find out that either nothing has been transferred into the name of the trust or something is missing. All right, so I can tell you, one case, the family, parents passed away, family came to me with a living trust. I didn't really read into it because it doesn't have any meaning without it's been funded. And it was missing relevant information. It was missing a will. It was missing Schedule A, that is the list of assets that has to be in the trust documents. And so we had to go to probate court. So that trust had no meaning. People paid a significant amount of money for it, from what I heard, but it means nothing. Well, when I'm your attorney, I usually supervise it diligently. I do not trust my clients because they never usually finish the process of transferring funds. So for important assets such as real estate, I'm taking care of it myself. So we sign a deed at the time of signing of the trust document, and I file it with the county myself, with the relevant county. So extremely important. Another case I'm having in court is when people transferred most of the property into the living trust. So funding is almost complete. But right now I have family, several kids who wanted to, their parents passed, and they faced the situation that even though several accounts were listed in Exhibit A and in Schedule A, but actually they haven't been transferred into the name of the trust. Well, that situation is a little bit easier. It doesn't take full probate proceedings lasting 2 years. It is merely, we're in the fourth month now in probate court, and hopefully, by the way, the petition has been approved, we're good. But now we'll have to wait for an order, and we don't know when the judge actually signs it. It's been already 3 weeks. All right, so it takes time, and we are at the mercy of probate judges, and I do not blame them at all for delays, because keep in mind, if you remember, there are only 9 probate judges here in Los Angeles County. Just think about it. Almost 12 million people, or how many million people we have here? 9 probate judges. Poor guys and girls, they juggle these cases. They barely have time to review them. And that process of this relatively simple trip to the courthouse lasting 4 to 6 months. It's called #petition. It is a specific form that we filed with the court. It's called simple or fast probate proceedings, expedited probate proceedings. And we ask judge to say, hey, judge, our parents created the trust. They meant for everything at the time of their death to be named to belong to this living trust, but they unintentionally omitted, forgot, mismanaged, whatever it is, to put these several accounts in the name of the trust. Please help us. Please sign off the order that these accounts belong to the trust. And when we receive that signed order, with that, we can go to the bank, show them this order, and the bank will release funds to the successor trustee, and ultimately all the heirs will receive their fair share of whatever the trust is telling them to do. So again, very important. The process is called funding. So if you have living trust, if you signed prepared living trust, I don't care where you created it, LegalZoom, some online forms, you download it, or with the attorney, or with a paralegal, or CPA, take a look at the names, how you hold assets when you receive bank statement. It has to say living trust, the owner of the account. All the, of course, real estate has to say your house has to hold the title as, let's say, husband and wife as trustees of this trust created on this date. Review your title, review your funding, so you are certain that your family is protected and there is no, there's going to be no unnecessary probate proceedings for which you have to pay. For example, the very last case I told you about, when they just forgot to put several accounts into the name of the trust, just in fees, just in costs of preparing of this petition, we incurred already about close to $1,500, so $1,400 something dollars. So, and it's just in fees, and of course there are attorney's fees, and this process is usually charged on hourly basis. Again, totally avoidable, totally unnecessary expenses. Make sure you review everything. There's holidays, you have time, hopefully you have time from work. Delegate some time to review check all your paperwork, check all of your documents, and make sure everything is written down, everything is straight, everything is in the right format, beneficiary is designated, funding is complete, etc. Okay. So also, of course, I wanted to discuss a lot more with you, but we have to end. So again, congratulations. Have a blessing holiday season, Christmas, New Year's, and we'll see you in a new year with the new programs, with new information. Have a good day.
Տարիների ընթացքում ձեռք եք բերում սեփականություն, կուտակում եք մեծ գումարներ, իսկ մտածել եք, թե ինչ է լինելու դրանց հետ ապագայում։ Լավագույն որակավորում ունեցող իրավաբան Մարիա Պրիմուշկոն իր բազմամյա հաջողակ փորձով կօգնի ձեզ ժառանգության փոխանցման, կտակ կազմելու եւ ձեր ունեցվածքն ապահով պահելու հարցում։ Estate planning, bankruptcy, personal injury եւ այլ իրավական հարցերով դիմեք MVP Law Group։ Ձեր ընտանիքի ապագան կախված է այսօրվա կայացրած որոշումից։ 818 788 7881